Rana is a man from Ghaziabad, Uttar Pradesh, India. In 2013, he fell from the fourth floor of a building and suffered severe brain injuries. Since then, he has been in a coma, or we can say that he is in a permanent vegetative state for more than 12 to 13 years. He cannot speak, move consciously, or live without medical support. Now, Harish Rana's father filed a petition in the Honorable Supreme Court of India asking for the permission for passive euthanasia, which is withdrawal of the life support. That means stopping artificial medical treatment so that the patient can die naturally. Passive euthanasia is something which is known as the stopping of life support treatment such as ventilator, feeding tubes, etc., which is also allowed in India but under certain strict conditions. So the family asked the court to allow doctors to stop Harish Rana's life support. Harish Rana's family said that his condition is irreversible. That means he cannot be cured. Also, the doctors confirmed that there is no chance of recovery. He has been suffering for many years without awareness. Keeping him alive artificially has no meaning. So the Constitution under Article 21 gives the right to live with dignity, which also includes the right to die with dignity. Here, the Supreme Court has formed two medical boards. First one is Primary Medical Board, which also confirmed that Harish Rana is in a permanent vegetative state. The Secondary Medical Board, which is also in this case AIMS, agreed that his condition is extremely serious. Recovery is almost impossible. So medically the case was considered hopeless. The government argued that the passive euthanasia is a very sensitive issue. There is a risk of misuse, such as families may force decisions. Strict legal guidelines must be followed. Courts must be very careful before allowing withdrawal of life support. The Honorable Supreme Court said important things like, what is the purpose of keeping a person alive when there is no hope of recovery? The dignity of human life is important and the feelings and consent of the family matters, but the law must prevent misuse. After hearing all the sides, the court reserved its judgments, meaning the final decision has not yet been announced. This case is connected with the earlier judgments such as in Aruna Shanbok case 2011. This was the first major case on passive euthanasia. There, the court allowed it in rare situations. Now, in Common Cause case 2018, Supreme Court recognized the right to die with dignity. There, the Supreme Court allowed passive euthanasia with guidelines. There, he also approved the concept of living will. In 2023, the Supreme Court gave certain guidelines such as there must be two medical boards which are required. Another one was that consent of the family is necessary and the legal procedure must be followed. Here, the Harish Rana's case tests how these rules are applied in real life. Now, the question which may arise is that how this case is even important. So, the case raises big questions. And the questions are that do humans have the right to choose a dignified death? Who should decide when life support should be stopped? How to protect vulnerable patients from abuse? Where should the law draw the line between the life and the dignity? This case can influence future euthanasia cases in India as well. Thank you.